Taoiseach, earlier this year, the Public Accounts Committee, of which I'm a member, was presented with a briefing note on the HSE's spending on legal services and the HSE's open disclosure policy. We were also told that a contingent liability of €2 billion is needed by the HSE to fund claims into the future. The briefing note goes on to say that international evidence has demonstrated that patients are often forced down the legal route to get answers, acknowledgement and apologies when things go wrong in relation to their care. And here we are 10 years on, and a woman in the worst of circumstances having been dragged through the courts in order to get answers. Indeed, had Vicky Phelan not been so brave to do what she did, then none of us would be any the wiser. Even if open disclosure is in place and these issues are mediated, what assurances are there that the identified failures will be remedied for others into the future? It takes people to go public and not sign confidentiality agreements to actually force this out into the public domain. How many other scandals have fallen under the radar because someone has agreed on a confidentiality clause? And at what point do these repeated failings lead to system reform? Taoiseach, the State Claims Agency alone, it's them alone which has the legal authority to determine the management of claims made against the HSE. On RTE last night on the news, the State Claims Agency said that in the case of medical negligence, the agency's policy is to admit liability. Yet, that is a direct contradiction to the statement of Caoimhe Haughey of CM Solicitors on the same programme, who said, in her experience, the State Claims Agency robustly defends every case and shows little or no compassion. Taoiseach, her comments are played out week after week when we see the HSE apologise after a settlement is made in the courts for medical negligence. There are a litany of cases we could point to, the one that Deputy Connolly has drawn attention to. Last week we had the primetime programme in relation to child and youth mental health services and the failures there. Do we have to continuously have high-profile failures or force people to lay themselves and their personal stories bare, either in the media or in a courtroom, in order for our systems to be overhauled? Taoiseach, you were the Minister for Health when the proposed legislation to make open disclosure mandatory was rejected. You were the one who made a decision to establish a patient safety office within your then own department rather than the impartial office which leading health experts said was required. Do you accept that in doing so you removed any hope of true impartiality when that office and within that office, and by failing to heed the World Health Organisation's advice to implement a mandatory open disclosure, your actions in 2014 have directly contributed to the current scandal? And at the time you were you're now Minister for Communications, Denis Naughton, said that in failing to legislate for mandatory open disclosure, all you were doing was maintaining a lawyer's slush fund. He also described your comments as absolute nonsense. Do you accept now that he was right?
Taoiseach, 3 minutes.
I just want to say that nobody in the government, me personally, nobody in this House wants to see sick people or terminally ill people dragged through the courts. Nobody wants to see that, and nobody wants to see prolonged legal cases going on for years. And I know the public doesn't want that either. It's not in anyone's interest. It's not in the interest of the taxpayers in the long run. It's not in the interest in terms of the health service when it comes to competent health service, and it's not in the interest of patients or citizens. I have looked into this, and I'm told by the NTMA and the State Claims Agency that 98% of medical negligence cases are settled or dropped and do not go to trial. Only about 2% go to contested court hearing, and those 2% go to court very often because the facts or claims are contested, and there will always be a certain percentage where the facts or claims are contested. In this case, as you know, in Vicky Phelan's case, the case against the state, against the HSE, was struck out, but the laboratory settled for $2.5 million without accepting liability. And while there may not have been a legal liability on the state, I do think there was a moral liability on the state, and there was a moral liability on the state to ensure that she got the information about her case that she should have got, and there was a breach of duty to ensure that that occurred. How are we going to deal with these matters? The first thing that we can do, I think, is to ensure that more cases don't go to court at all. And the way we can do that is by building a culture of truth in our health service. And that means open disclosure. And it means many other things as well. And bear in mind, this is the government that legislated for open disclosure in the Civil Liability Act last year. And that will be brought into law, commenced into law before June this year. And we will also legislate, as we indicated we would do last year, as we indicated we would do in the programme for government in 2016, for mandatory open disclosure in the most serious incidents, those that are considered to be serious reportable incidents. We also need to reform our laws to make sure that legal cases proceed more quickly. And let's not forget that the legal profession can help with this too. Where something goes legal, there are two sides, and both sides need to work together to make sure that cases aren't prolonged. And we can do that in a number of ways. For example, pre-action protocols, they are now legislated for by this government. Periodic payment orders, now legislated for by this government. And mediation, now legislated for by this government. So just in the past year or two, 3 major pieces of legislation designed to do exactly what you say should be done. The Civil Liability Act passed in the last few months, the Legal Services Regulatory Authority legislation passed in the last few months, and also the Mediation Act passed in the last few months. And I did see an example described yesterday on the news of a case that was handled very differently, the case of a young boy who had a birth injury who settled for €5 million, and that was done by mediation. And the solicitor described on the 6-1 News last night how things can be done differently, and very often are done differently, and we need to see much more of that. In terms of the Patient Safety Office, I am the Minister of Health who actually set it up. There wasn't one before, and I'm the one who set it up. And when you do things, you need to do them in a stepwise manner. It's not possible to make all reforms happen overnight, but we are making those reforms happen.
1 minute.
Taoiseach, when you say 98% of claims, or 98% are not pursued through the courts, there's a whole lot of different things that can happen there. People can get afraid of the might of the state and the consequences for themselves, and we know that. We know that settlements are made on the steps of the court routinely. And then we don't know what gagging orders or confidentiality agreements are hiding some of what we're seeing. There seems to be a conflict with what the State Claims Agency's approach is and the HSE's set approach is. And that conflict has got to be resolved, because we'll continue to see cases going through the courts. Taoiseach, you set up a voluntary as opposed to a mandatory arrangement, which is not yet in force. Do you regret not setting it up as a mandatory arrangement? You also set up, you told us, an office within your own office, as opposed to what was recommended in relation to an independent office that was recommended by health experts. Why did you do that? Why was the approach you made the better of the two approaches? And what information had you to do that produces a better result from what you did?
Over the past 10 or 20 years, and these issues are not new, over the past 10 or 20 years there have been any number of ministers for health, and there have been any number of ministers for justice, and bear in mind this is justice legislation, not health legislation, any number who could have acted on these matters. I was the one who actually established the Patient Safety Office when there wasn't one, and I'm head of the government that actually brought in the legislation to legislate for open disclosure and has done these things. Any number of justice ministers or health ministers could have done these things in the past. We're the ones who did it. The Civil Liability Act, the Legal Service Regulation Act, the Mediation Act, and also the establishment of the Patient Safety Office. In terms of the difference, in terms of open disclosure, I did go through this yesterday. I'm happy to go through it again and explain it in detail. Open disclosure and duty of candour already form part of the Medical Council's guidelines for ethical practice by doctors. They are not optional, and doctors can be struck off for not following them. Open disclosure is policy for all HSE staff and has been since 2013. and they can be disciplined for not following open disclosure. The decision that we made, and it's there in the programme for government in black and white for anyone to read it, is to proceed with voluntary open disclosure for all errors and to have mandatory open disclosure for those most serious errors, those that are called serious reportable errors, and that's explained as well. The Civil Liability Act supports voluntary open disclosure and puts it on a statutory footing. We enacted that in this Dáil in the last couple of months. I, as Taoiseach, led the government that did that. People have been talking about that for 10 or 20 years. We actually got it done as a government, and that will now be commenced by June. And that is designed to create a culture of truth in which doctors, nurses, midwives, other people, scientists, feel that they can make an apology without it being seen as an admission of guilt, feel they can admit a mistake without it being used against them. And that's what we need to do, is create a culture of truth in the health service where people operate in that space. And now the next step, and we indicated we would do this at the time, is to legislate for mandatory open disclosure in those serious reportable incidents. But it's a mistake if people believe it's as simple as passing a law. You need to change a culture in a health service so that people change their attitude towards these things.